May it please the Court. Good morning. My name is Aviva Jerusham, and I represent the appellant Wally Jake Simon. And we're here on the interlocutory appeal of two disparate issues. The first issue is the denial of a motion to suppress statements under Miranda. And that issue is a first impression in Massachusetts. And the question raised by that issue is whether or not the presence of counsel during an custodial interrogation obviates the need for the Miranda warnings to be provided by the Commonwealth.
Well, help me out here. Miranda advises a person that they have a right to counsel, right?
As one of the warnings, that's correct.
And they've got their lawyer right there. In fact, our facts are that they're in the lawyer's office, aren't they?
Yes, they are.
Another part of Miranda is they're told if they can't afford a lawyer, counsel will be provided. Well, that's not an issue because their attorney is right there. They're in their lawyer's office. That's
absolutely correct, Justice Ireland. However, that's only Part 3 and Part 4 of Miranda. The first part is clear and unequivocal in that the suspect is required to be advised that they have a right to remain silent. Secondarily, anything they say can and will be used against them.
Just in terms of the chronology here, as I understand it, the defendant conferred with their attorney privately.
It is
meeting with the police in the conference room.
That's correct.
Now, we don't know what they talked about.
Absolutely, we don't.
But there was some kind of conversation between the defendant and their counsel.
That's
about
correct.
45 minutes, is that right? For about 45 minutes?
About 45 minutes to an hour, yes.
After the police had spoken to the defendant already
about
wanting to talk to him.
Right. He didn't know what they wanted him. He didn't know the subject matter of the discussion. He knew that something had happened in a specific town. They wanted to talk to him. They pat-frisked him. He was obviously in the presence of approximately half a dozen police officers. And at that point, he indicated that he was on his way to speak with his attorney. Not about the subject matter per se, or whether it was about anything related to why the police were present.
So he spoke to his lawyer for 45 minutes. Then the police joined him and the lawyer in the conference room.
That's correct.
After they were invited?
Well, yes.
And the lawyer invited them, right?
The lawyer,
he will speak to you, right?
Correct. That's correct. The lawyer said he will speak to them. The lawyer did not say he had advised his client of the Miranda warnings, nor was that his obligation. The defendant, in fact, the attorney in question specifically filed an affidavit saying he had not advised his client of Miranda warnings. But notwithstanding that, I think this is essentially a red herring in this particular issue, because I think Miranda and Dickerson versus U.S., which is a 2000 case, the Supreme Court addressed the issue of whether or not the fact of whether a lawyer was present would specifically obviate the need for counsel. There was a statute, a federal statute, that essentially was analyzed as to the propriety of different steps that could be taken in lieu of the current Miranda warnings that were in place. And Dickerson specifically said that this was not, the statute was unconstitutional. The statute did not correctly apply the standards of Miranda, and that court declined to overrule Miranda, declined to overrule the steps that Miranda required. And each case in Massachusetts, Adams specifically says you are required, you meaning the Commonwealth is required, not the defense attorney, is required to give specific warnings. And those warnings are that you have a right to remain silent and anything, and what will happen if you waive that requirement. And the Commonwealth has the absolute burden, beyond a reasonable doubt, to show that that was waived voluntarily, knowingly, and intelligently.
Okay, but the reason behind Miranda in terms of its history was concern over the application of the voluntariness of confession, the totality of circumstances, and after struggling with that for a number of years, the court says we're just going to provide this prophylactic rule, just do it. And that way we don't need to address whether the confession is voluntary. Are you saying then that the Supreme Court in 1967 understood that the Miranda would apply even to counseled custodial interrogations?
It dealt with counsel custodial interrogations. It addresses that issue. If you read Miranda in detail, and it required me to do it, and I have to say I have not done it in years, and the Commonwealth goes to great lengths saying the presence of counsel is the only prophylactic measure necessary to ensure that the defendant's rights have been preserved. Not so. The court had the opportunity to deal with the issue of whether or not the presence of counsel would obviate the need to give them warnings, and they said no. In fact, if you read Miranda, the presence of counsel and the trial judge in the particular case of this motion in his findings essentially focuses on why the presence of counsel is appropriate and helpful and necessary, namely to alleviate the coercive atmosphere that law enforcement may have, not to delete the requirements of both Article 12 and the Fifth Amendment, advising a defendant that he does not need to speak, and the consequences of speaking.
But if you're right, then why was Miranda limited to interrogation? Why not say, even if the defendant's about to blurt out a statement, you've got to say, stop, you have the right to remain silent, and whatever you say may be held against you. But Miranda doesn't say that. Miranda says it's only when there's interrogation that you have to give those warnings.
That's correct, and in this particular case, there was interrogation.
Ms. Schurzman, could you just move that back a little bit from you?
I'm sorry, I'm just trying to.
No,
if
no,
you can all hear me, I'm more comfortable with not sounding like I'm on stage.
There.
Thank you.
What do you say to the Commonwealth's point, I think, that in substance what you're suggesting is that Miranda or the warnings become the right themselves, itself. And so to the extent that it has an absolute quality, that it's substituting the Miranda warnings for the right against self-incrimination, if I have that right. I mean, so it's sort of raising it to a place that it wasn't meant to be, that it's a protective prophylactic measure, but not the right itself. And so that the right itself, if protected because counsel is there, is protected in this case.
Again, when I've read Miranda, and I think Miranda's pretty clear, and if you read Dickerson, it elaborates on, I think, your question. I don't think Miranda essentially elevates the right against self-incrimination. I think what Miranda does is, after much thought and several cases appended to it, created a system whereby the Supreme Court felt that there was a mechanism by which a defendant would be advised of what his right was, what the consequences of that right was, and further, if he wanted to additionally consult with counsel. And that's where I think there's some confusion, is that essentially the presence of counsel is not to only decide whether or not he should waive his Miranda, but in addition, as an additional tool, if you might, but not the presence of counsel for the purposes of waiving that tool. And again, the court went on at length about the presence of counsel and why the presence of counsel was so important. And it did not go to the issue of whether or not a defendant had the ability to consult with counsel on waiving that right, but more as a means to make sure that coercive means were not employed within the interrogation. And I think the Miranda Court and Dickerson is very clear on both of those issues. In this case, there was no question, and I know the Commonwealth would like this court to find there was no interrogation. But I would ask the court to find specifically that there was. It's clear in this particular case, and I think the case of Commonwealth versus Groom sets out the 4 steps for the court to consider. But in this case, the defendant, while he was in his attorney's room or his attorney's office, this did not confer any special protection or ability for this attorney to create a soft...
What happened, though, between the time that he was on the street and did, in fact, leave the presence of the police and the time in the attorney's office that would change the situation? So, because on the street he knew he was free to leave. He did, in fact, leave.
He did, in fact, leave?
He left the police and went up to his attorney's office.
Well, technically that's true, but to envision the circumstances of what he did, he left the street, went up into an office, and his last view was to see 6 police officers essentially outside the building guarding the door. I don't think that that's a circumstance where anybody would feel that they were free to leave. And he was in the presence of his attorney, who was given the instruction, when you're ready to talk to us, let us know. In point of fact, the attorney did not call them, did not say, we're ready to talk to you. The police officers who had received the information about the positive photo array identification then called the attorney and said, can we speak with your client? And it was at that point, again, that the defendant knew that the police were still downstairs and had every expectation to believe that they were still downstairs, because he was told on his way out to his attorney's office that the police were going to be waiting to speak with him.
But that doesn't, I mean, isn't the strongest argument for that at the time that they spoke, or before they spoke, the trooper had indicated that they did have the positive photo ID, which was a different fact than had been the case when they were interacting on the street, correct?
Well, certainly when he went into the office, the question of whether or not there was a custodial interrogation, I still think it was there. But when they came up to the office to speak with him and told him that he was a suspect in a double shooting with a homicide, I think that removed any doubt for anyone that he was not going to be free to leave.
Not only a suspect, but had been identified as
That's
the person,
correct,
as the
absolutely. I don't think there was any question that he knew that he was not going anywhere at that time.
Did the attorney shed any light on, you said he gave an affidavit that said he did not advise him of his Miranda rights?
That's correct.
Did he shed light on what he did advise him on?
No, he did not. The indication from the hearing was that the meeting had been pre-scheduled, and that would be evidenced by the existence of a tape that the defendant was delivering to his attorney's office. So it would appear that the presence of the defendant at his attorney's office on the same day of this interrogation was a coincidence and not scheduled for advice on this particular issue. Mm-hmm. Exactly.
But they both knew before the 45 minutes began that the police were down there to talk about this case. So
that's correct.
Yeah.
Or they could assume that that was the case. Whether or not they ever got to talking about the Miranda warnings is a question of fact. But again, I'd ask the court to consider that it's a dangerous path to go down if the court is going to allow a case-by-case analysis of the facts to determine whether the presence of counsel did in fact do the job for law enforcement. Because Miranda and the subsequent cases, as I've already said, are clear that that is not permitted.
So you don't, and maybe it's in the amicus brief, you don't make anything that Article 12 is stronger than the Fifth Amendment in this regard?
It is. Article 12 is more expansive on this particular point in support of the defendant's rights than the Fifth Amendment. And Adams specifically says, if you look at Commonwealth versus Adams, which is both in my brief and also the amicus brief, it says that there just can simply be no substitutions, that the requirement by law enforcement to give these warnings is absolute. And there can be no circumstances which can alter that. And I know the court in New York and Voss, and again, the fact pattern is distinguishable, but it's not a path that I think the court can go down. And that case was erroneously decided because of Miranda, because of Dickerson.
Your time is up.
Okay, thank you.
Thank you.
And I rest on my brief on the other issues.
Good morning. May it please the court, I'm Middlesex Assistant District Attorney Marion Ryan, representing along with Assistant District Attorney Fawn Bolero, the Commonwealth in this matter, asking the court to affirm Judge Zobel's denial of both motions.
Why should we start down this road? I mean, we have a rule. It's very clear. It's crystal. Why should we start down this road and start taking every case where a lawyer has had some involvement in the interrogation and beginning the analysis all over again?
Respectfully, Your Honor, I would suggest that it is, as Justice Blatchford mentioned, the fact that this court and this Commonwealth have a long tradition under Article 12 of not following the common road, of extending a greater protection to defendants in these cases. And when you do that, when you look at the facts and the law here, Article 12 and that sense of what does Miranda really mean, when should it be applied, compels the court to follow what the Commonwealth is asking. And
But okay, so we have next case. The person being interviewed, the suspect in custody, is actually a lawyer. Well, he's a lawyer. He knows what his rights are. Why should it apply there? I mean, maybe he's even a criminal defense lawyer. What about that case? Or the defendant is a pro se, very experienced, talented person, has represented him in criminal cases before. Well, why apply it there?
I think there are a host of reasons, beginning probably with the axiom that an attorney who would represent themselves as a fool for a client, that one would want to come to a different result in that case. But that is not where we are here. What we are here is exactly what the court said in Mavrodakis, that really what Miranda said was you have the right to be informed of your opportunity to consult with an attorney.
That's definitely one of the things Miranda said. There's no
Yes.
question about that.
And what Mavrodakis and the court in Mavrodakis said is there is a very great difference between being told that, perhaps not being able to afford an attorney, perhaps not really understanding what that means, and having the concrete opportunity to consult with an identified attorney. That's what this defendant had.
Yeah, but in Mavrodakis, the defendant had already gotten his Miranda warnings.
Yes.
They had been administered, and the lawyer was downstairs. The police didn't tell him that the lawyer was downstairs. So that's not really a good case for the question that's put to you, is it?
I would suggest it is, Your Honor, because in Mavrodakis, the police declined to let the defendant know that his attorney had called or was downstairs at various points during the evening. And the argument was that the defendant never enunciated, I'd like to have a lawyer, so they didn't have to do that. And the court said, just telling somebody they have a right to a lawyer, yes, Miranda requires that, but we, under Article 12, are going to say sometimes that doesn't mean a lot.
Okay, so maybe in these circumstances, if the police slip up and forget to inform the defendant that he has a Fifth Amendment right to a lawyer when the lawyer is sitting there, maybe it doesn't matter in those circumstances. But he has a separate Fifth Amendment right to remain silent, and he wasn't advised of that right.
Your Honor, I think that goes back to Justice Botsford's question, which is, what is it that we are concerned with? Are we concerned with the rights? Is it, does a defendant in a criminal case have a right to have the right, or does he have a right to have the protection? And it's the Commonwealth's position that what he has is not just the right to have the words read to him that may or may not have some meaning, but what is best, what Miranda at page 466 says would have been the case. If every time a suspect was in the police station he had a lawyer, the court said we wouldn't need these warnings.
So what if the lawyer, in this case an experienced criminal lawyer, was a civil lawyer, actually never handled a criminal case in his life? The defendant had been going down to talk about a civil case. So what do we decide now? Well, there was no advice of rights, but we assume this lawyer probably advised. Lawyers would do that. They know criminal stuff, even if they're not criminal. Is that the next case? We have to decide how experienced the lawyer is to decide whether the defendant maybe was advised of his rights.
I think, Your Honor, that there are an endless number of permutations of
The
who would be,
problem.
if their son is a law student, what happens. But I think that is what is always the case in Miranda cases. We look at what happened. Was the defendant given his rights? Did he understand his rights? Did he have an opportunity to exercise his rights? And I think that if you look not only at what happened, but the purpose of Miranda, I think there can be no question that Miranda is a prophylactic rule. The court in Miranda said at that time, we are appalled by the kinds of interrogations that are going on. We are going to try to get police departments across the country to be doing the same thing. And the simplest way, maybe not the best way, and it articulates that, to do that is to just say there's a rule. Here's a list of things. You say this, you have to at a minimum do that. In no way did the court say the reason for that was some great other meaning or right to have those words read. It was looking at the other end to keep the police from doing what the Supreme Court believed to be frightening and wrong, to be coercing defendants into making statements. If you apply that analysis to this situation, the police in this case don't need to be punished. What they did was they permitted a criminal defendant, whom they were already interested in when they saw him outside, to go inside, to have a conversation.
We're not talking about punishing. We're just talking about whether a clear rule that that a person in custody needs to be advised that they have a right not to speak to the police and that anything they say may be used against them in a criminal proceeding, whether that's something that needs to be articulated. This isn't a matter of punishment. It's a matter of ensuring that there's uniformity of practice to protect constitutional rights.
It's not just punishment in the sense that what was discovered or what was said will be suppressed, but it is, if it's to be instructive, and I'd suggest that is one of the points of the court articulating its decisions in this area, is to be instructive. If we are attempting going forward to say, what should the police have done?
Let me ask you this. Here's something I'm puzzling over. It's not this case, but if you have a defendant who's been involved in the criminal justice system repeatedly and they know the Miranda rights as well as the police do, would you say, well, this defendant has been arrested by the police 25 times, so obviously he knew he had a right to counsel and not to make a statement and so forth. Is that where we're going?
I would say, Your Honor, that it is not this case. It is sometimes a factor. As the court can see in this case, over defendant's objection, some prior convictions were admitted, showing that this particular defendant did have a familiarity. Do I find the same assurance that, going back to Mavrodakis, that he really understood? If you've been advised of your rights 10 times, and you lack education, you lack resources, you lack a number of things, so they are meaningful to you, am I as confident that that defendant is as protected as I am about this defendant? No, I am not. So I think that's yes, there are defendants who I'm sure one could show had effectively exercised their rights at a number of times.
I don't see Mavrodakis as really being very helpful, because my memory of the facts in Mavrodakis was the father made efforts to get attorneys available, called, and they called the police, in fact, showed up at the police station, and the police didn't cooperate. But I'm not focusing so much on the instant case, but the logical extension, if we do what you want us to do. Wouldn't we be in a position where we would say that a defendant's experience with the criminal justice system would negate the need for Miranda?
I don't think so, Your Honor. I think there is a difference, and no courts that I was able to find have ever said that, although that sometimes is a factor in understanding whether there was an intelligent waiver, have ever said that the fact that you've been Mirandized 10 times before means on the 11th arrest you don't need to be Mirandized.
You would draw a bright line at, you have a lawyer present.
Yes.
Period.
Yes, and I would suggest more than just present. I think this case would be different, for instance, if
who you've had an opportunity to consult.
you had an opportunity for some meaningful consultation with. And I think that changes the picture.
But how do we know it was meaningful consultation? Because they were there for 45 minutes or an hour or whatever, and maybe the lawyer said, look, I just have a certain amount of time and we got a lot of problems in this case involving the tapes, let's talk about them. And he never got to any meaningful consultation about discussion with the police.
I think we know that for several reasons, Justice Cowan. I think we know it, first of all, because common sense would fly in the face of, I'm an attorney, I'm called outside onto the street, there are state troopers there, my client is there, I'm allowed to bring him back into my office. I know there's going to be a call out that we're going to resolve what's happening here, that I would now sit down and ignore that matter and have a discussion of some other matter.
Maybe there's a deadline on this case involving the tapes of this morning, and the lawyer's afraid this guy's going to be arrested right now after the discussion, so we've got to resolve this matter with the tapes. It's $1 million deal or something.
Well,
I mean, we don't know, and the Commonwealth has the burden of proving beyond a reasonable doubt, and we don't know what happened in the time, and the attorney never got to the point of calling the police either. The police just came up.
we do know, Your Honor, that there was some discussion, because when the call was placed, they had agreed to give him a few minutes. They waited somewhere between 45 minutes and an hour. In the meantime, they get the information about the identification. They make the call. At that point, Attorney Solomon doesn't say any of those things. He says, and I would suggest that this must lead to the conclusion that there had been discussion, the defendant's prepared to speak to you. Come on up.
So you're saying essentially defense counsel can waive this right? Because I take it what you're suggesting here is not only was the defendant informed of his Miranda rights, so-called, he also waived them, even though we don't have a written waiver, we don't have an oral waiver, we don't have any kind of waiver at all, except the defendant answered questions.
We are not asking the court to adopt a new bright-line rule here. What we are saying is that in these particular circumstances, on these facts as found by the court after a hearing, that defendant's protection was, the defendant received the appropriate protections.
And waived those protections.
Yes.
Well, aren't you also saying this was not interrogation?
Your Honor, I think it's clear that there were some questions.
So you concede this was interrogation?
I concede that there were questions put to the defendant, yes.
You're not conceding that he was in custody.
I'm not conceding he was in custody, no.
Could I, if we have enough, I just want to ask you about the other issue, if I could. If you take Nesbitt and you talk about, it's even though testimonial, it could still come in if it's seeking, sort of emergency, if it's seeking medical care or the emergency is still going on. In this case, I guess my question is that as one reads through the conversation between that victim and the dispatcher, it gets to a point where at least one observer might say there's really an interest in finding out who this person is, not because of anything related to safety of the police when they get there, but because they need to know who it is for purposes of investigation. So, I mean, do you think they're, I guess I'm just wondering whether, I think this was a 6-minute conversation, is that right? I mean, it goes on for a long time, and so I'm having some trouble putting the whole 6 minutes into a protected category, if you will.
I think what changes that, Your Honor, is that there is sort of midway through the conversation, the victim, the wounded victim, has brought up the name Wally, and there is an inquiry as to Wally who. And then that victim appears to be fading, and there's a long part of that conversation that is an attempt to keep him conscious to find out what happened.
Right.
And then at some point there is a circle back to that question of who is Wally. And I would suggest that one can read that as one of two things. Number one, some attempt to keep the victim focused, because in fact it seems to have that effect. And I would suggest that's
and
not
conscious,
unreasonable
right.
for a dispatcher. You're saying, because before that he's saying, I'm going to sleep, I'm losing blood, I'm going. When the dispatcher tries to get him back on what he was, just the last question before he starts to go out, he takes him back to that, he does appear to come in a little bit. And he starts to talk about the gym and all of that. So I would suggest there is a real medical purpose in that. I would suggest further that the end of that tape, which in listening to that tape is frightening, is that what you have, and at least the dispatcher has been able to piece together, you have a several-tenant building. The wounded victim is on one floor. He's saying, although it's a little hard to figure out how he knows, he can hear the breathing from downstairs. And there seems to be a real confusion about, clearly he's immobile, because he says, I'm sitting on the floor, where anybody else might be. And when you hear at the end of that tape, as the officer's responding, clearly frightened, who else is in here? Where is everybody? So I think that certainly bodes more than that one question as to why they were asking that there was a real safety issue. First of all, for the responders, and I would suggest there's certainly a safety issue in the momentary nature of this for where this man has gone, who clearly has already shot 2 people. So I would suggest that that would justify the admission of that tape. Thank you, Your Honor.
Thank you, Ms. Ryan.